Hello, everybody. So glad you are here. Thank you very much for being here. If you're into true crime, but you like to cut past the sensationalism, what I like to call the fluff, you are in the right spot. I'm glad you're here. I've had a bit of a hard day. It's going to be one of many, I think. Here in Western Pennsylvania, we have a murder trial going on that you will not see on television because it's Pennsylvania. But it is so egregious and so sad. Um, it's the murder of a 2-year-old who was beaten to death allegedly by his mother's boyfriend. And when she presented herself at the police station, she also had been beat up quite a bit. So it's a sad case, and today was the day where the forensic pathologist testified, and that included some very graphic photography from the pathologist's office. It was tough, really tough. I'm so glad that there are people out there working to investigate and prosecute these kinds of crimes. They go through a lot in order to do that. And I'm grateful for the pathologists and the coroners and the medical examiners, the police officers, the crime scene investigators, the detectives, the prosecutors, the prosecutors' assistants, the judges, the juries, all of them, because it is not an easy task, not at all. So very grateful to them. Speaking of heartbreaking cases, we've been talking about this one for a while. It is the heartbreaking case of Madeline Soto, who, at the age of 13, was murdered allegedly by her mother's on-again, off-again boyfriend, a man named Stephan Sterns. She went missing on February 26th of 2024. On March 1st, her body was found dumped in a field next to like a hedge of bamboo, not too far, relatively speaking, from home. And Mr. Sterns was found to be in possession, allegedly, I believe it, in the possession of about 1,700 pieces of digital evidence, photography and videography, depicting his abuse of Madeline that had taken place over the course of at least 5 years. And Mr. Sterns his case is moving along in the courts. As you guys know, there was a giant dump of motions in the case, something like 48 motions, if memory serves. And we went over some of them, but there's one that I want to go over tonight that I think is, I think it's interesting. I think it's telling of what might come when it comes to his own defense. Keep in mind, guys, that in the United States, less than, I shouldn't say this in every location, but the rule of thumb is about 1% to 2% of cases ever make it to trial. Many of those cases that almost make it to trial get pleaded out or pled out. I'm never sure how to say the past participle of to plead. Anyway, about, right before the trial is to begin. So they go through this whole song and dance only to, I guess, make a plea deal. So that might happen in this case. Nevertheless, the process does go on, and the motion that I want to talk to you guys about today and read it with you is titled "A Motion to Exclude Evidence or Argument Designed to Create Sympathy for the Deceased or Vilify Mr. Sterns." And when I saw this, I thought the chutzpah that this legal team has. I mean, you want a legal team to have chutzpah for sure. Like, you would want this legal team on your side. But I'm sorry, I sat in a trial today where Oh my goodness. I, I, I have to write up an article for my company tonight, and I am just dreading it because I'll have to open my notebook that has whatever it is, my 15 pages or so of notes, to go over it all again. But I'm telling you, there was not any evidence that was entered into the record today that did not create sympathy for the deceased. And I can't imagine that in a case like Madeline's, that jurors won't feel sympathy for her. She was allegedly abused since she was 8 years old. I think that we should feel sympathy for her, and the jury is going to be the judge of the facts, and maybe those facts do vilify Mr. Stearns, but nevertheless, let us read, because I find it interesting. There will be stuff to talk about. By the way, you guys see at the bottom of the screen there that if you're new here, welcome, glad you're here. If on my channel, I don't know why I did this. I know other channels there's like a standard QQQ for a question. I didn't know that, so I just put GF. A lot of people think that means girlfriend, but it does not. It means Gavin Fish. So if you have a comment that you would like me to read, go ahead and put GF in your comments. And for example, here's one from Helen. Hi from South Australia. Good to see you, Helen. Oh, no, wrong one. Derek Clues. Gavin, I don't know why, but when you say Little Miss Maddie, it just warms my heart. I think she is somewhere feeling our love. Thank you. Man, I sure hope she is. But yeah, Little Miss Maddie. I don't even know how to say this like better than anybody else can say it, but I mean, this is a child. I'm feeling all the feels today. I'm feeling every single one of them. And oh my goodness, yeah, I'm with you, Dara. I hope that she does feel our love. Okay, let's get back to this. So put GF if you want me to see your comment. Okay, motion to exclude evidence or argument designed to create sympathy for the deceased or vilify Mr. Stearns. Now comes the defendant, blah, 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 blah. Now let's read this first one. Stephan Sterns, through his undersigned counsel, and respectfully moves this honorable court to prohibit evidence or argument during both the guilt and penalty phase. Oh, does that seem to, I guess, infer that they know there will be a penalty phase? Oh my goodness. That is designed / presented with the intent of or would have the effect of creating sympathy for the deceased or vilifying Mr. Stearns. Such evidence and argument are contemplated to include, but may not be limited to, that which details the impact of the offense on the friends and or family of the deceased, the impact of the offense on the community, the life histories of the deceased, or any personal characteristics of the deceased or of Mr. Stearns. In support of this motion, the defendant provides the following. Before I go on there, I guess I don't. I'm trying to think of what happened in this trial. I don't think that they asked, for a life history of the victim. And I'm trying to think of other cases that I have followed. I don't think that they do. I think that's kind of just standard operating procedure. But okay. He's charged by indictment. Their notice of intent to seek DP. Florida law has consistently held that evidence designed to create sympathy for the deceased is inadmissible in the guilt-innocence phase. Well, then why are we talking about it? If that is that is the modus operandi, why do we care? Okay. The Florida Supreme Court reaffirmed this line of cases in Jones v. State. See also Lewis v. State, Roe v. State, Ashmore v. State, Hathaway v. State. Florida law has consistently prohibited such evidence in the guilt-innocence phase of any trial, capital or otherwise. This type of evidence, along with evidence designed to vilify the defendant, is offered only to inflame the passions and emotions of the jury and encourage a jury to make findings and decisions based on emotions rather than a logical evaluation of the evidence presented at trial. Such evidence is not relevant to any issue in the guilt-innocence phase. It is virtually always highly inflammatory and prejudicial, outweighing any possible probative value it may have. Again, I don't think that anybody is doing this. They cited all this case law. So why make the motion? I don't understand. Okay, the admission of such evidence would violate the defendant's fundamental rights pursuant to Article 1, subsection 2, 9, 16, and 17 of the Florida Constitution and the 5th, 6th, 8th, and 14th Amendments of the United States Constitution. Okay. Again, then why are we talking about this if it's not standard operating procedure? Okay, likewise, the admission of evidence concerning the deceased or the circumstances of the offense is inadmissible under Florida law at the penalty phase or sentencing phase. Statute 921.141 specifically limits the prosecution to the aggravating circumstances listed in the statute. None of these aggravating circumstances are related to the character or personal characteristics of the deceased or the impact of the death on the friends and family of the deceased. The Florida Supreme Court has recognized that the statutory limit on aggravating circumstances forbids the introduction of this kind of evidence. Florida's DP statute, section 921.141, limits the aggravating circumstances on which a sentence of death may be imposed to the circumstances limited in the statute. The impact of the murder on family members and friends is not one of these aggravating circumstances. Thus, victim impact is a non-statutory aggravating circumstance, which would not be an appropriate circumstance on which to base a death sentence. Okay, so they're talking about like victim impact statements. Typically, at the end of a trial, if a person is found guilty, when you get into the sentencing phase, the family does typically have the opportunity to read a victim impact statement or address the court in some way. I've recently seen this. Oh, it was so sad. Guys, it was so sad. I was at the sentencing of a man who had been convicted of murder. In my opinion, while I agree with the jury that he was guilty of the murder, there was no question about that. They came, I think, to the wrong conclusion, and they did not allow him to. They did not find him guilty but mentally ill, which would have given him some help moving forward. Anyway, I sat there as the family members read their victim impact statements, and the wife of the victim and at least one child of the victim, specifically said to the court, "I have hate in my heart. I hate him." And I just thought, what a sad state of affairs there. Not only were they victimized by when their loved one was taken from them, but for the rest of their lives they hold on to that, and it only hurts them. It doesn't hurt the person who perpetrated the crime. It only hurts them. So sad. But anyway, they got to read victim impact statements. They were specifically told not to address the defendant. They had to address the court. They had a hard time doing that. But I think that's what we're talking about here, that in the sentencing phase, they're saying the impact statements may not be statutorily allowed, I guess. It's hard for me to say as a non-lawyer. Okay, the Florida Supreme Court has specifically disapproved of introduction of this kind of evidence before the judge alone. Florida statutes 921.143 does not allow this type of evidence in capital cases. Although this statute allows the victim or next of kin to speak at sentencing, okay, the Florida Supreme Court has specifically held in Grossman Supra that this statute does not apply in capital cases. Huh. So the court stated, accordingly, we hold that the provisions of section 921.143 are invalid insofar as they permit the introduction of victim impact evidence as an aggravating factor in death sentencing. Interesting. The prosecution may attempt to argue that Payne v. Tennessee somehow authorizes the introduction of this type of evidence. First, Payne deals only with whether the Eighth Amendment bars victim impact statements during the penalty phase of a capital trial. There is nothing in the opinion that indicates that the admission of such evidence in the guilt-innocence phase would not violate the due process clause of the 14th Amendment. Payne states that in some specific circumstances, the evidence can be so unduly prejudicial that its introduction in either phase violates the due process clause of the 14th Amendment. So this is a 1991 case law, a federal case law that went, I'm guessing, before the Supreme Court. Okay. Second, Payne continues to prohibit the admission of a victim's family members' characterizations and opinions about the crime, the defendant, and the appropriate sentence. Finally, Payne, like any United States Supreme Court decision, merely deals with the question of whether the practice at issue violates the United States Constitution. Neither Payne nor any other United States Supreme Court case deals with the question of whether such evidence is admissible under the law. Interesting. This got interesting to me. Finally, sympathy evidence is clearly inadmissible under Florida law. A long line of Florida cases, as detailed in Jones Supra, meaning above, prohibit such evidence in the guilt-innocence phase. The introduction of such evidence in the penalty phase or before the judge would violate the clear limits on aggravating circumstances imposed by Florida Statute 921.141 in Grossman above. Let me pause here for a second. We're talking about pretty specific legal doctrine, right? Legal case law. And I am not a lawyer. You watching may be a lawyer, which I would love your comments on this stuff. But it feels to me, and correct me if I'm wrong, and I'm happy I'm wrong enough. It doesn't bother me that I'm wrong at all. But DP is such a contentious issue in the United States of America. It's extremely contentious. And I think that's for good reason. I think that people who oppose DP do so for valid reasons and they can articulate those reasons really well. I don't agree with them, but I respect the argument, and I think it's a good argument. Or I think many are good arguments. But it feels to me that the reason they would put this motion before the court is to, what is the word I'm looking for, is to hedge against losing and being able to have something to appeal later on if the judge's decision goes a wrong way. And maybe that is the reason there are so many motions in this case. We're talking about a capital case, and we've got people on both sides of the question with deeply held convictions and concerns, and it doesn't seem to matter what happened to this little victim. The penalty to some is too severe. Of course, Madeline got the death penalty. I mean, she didn't get to argue her case. She didn't get to put 48 motions in front of somebody. But anyway, maybe they're just hedging against potential. They're hedging against a loss so that they might have things to appeal on later. That's what I'm guessing. Let me go to your comments about this. I'm curious what you guys think. Let me clear this. Go here. I'll go bottom up. The jury recommend DP. But isn't it up to the judge if he or she gives the DP in sentencing? Yeah. So I'm not sure about Florida law. Is that true that it's the jury that makes the recommendation? I'm trying to think about that. You guys know that I was in a jury on a double homicide case. I think in that case it was different though. They weren't seeking. It wasn't a capital case, but they were trying a juvenile as an adult. Yeah, so it's a different thing. I'm not sure if that is the case, Helen, but I do believe it's up to the judge. I mean, there would be sentencing guidelines within which they would have to stay. And I don't know specifically about Australia about Florida, because it varies state to state. We might have to look that up. Yeah, no idea how it works because we don't have it in Australia. Let's see. Oh, man. Let's see. Gavin, Rashana Sweeting says, Gavin, I don't think they should even have a trial straight to the DP. Why do we need a trial for? Well, no, the law is important and the process is important. There was I wouldn't call it an outburst today, but there was an admonition by the judge today in the trial that I was covering to members of the gallery. And basically he said, this is an open public meeting, but it can be taken away. And I guess the issue was that somebody in the gallery was addressing the defendant, was talking to or about the defendant within his earshot. Anyway, and the judge was like, the process, we have to protect the process to afford the defendant a fair trial. So if you can't keep it under control, you're out of here. And so why do we need the trial? No, we need the process. We can't just go straight to taking somebody's life. We just can't do that. If I'm understanding you correctly. Patty Olson says, Gavin, poor Stephan Sterns doesn't want to be seen in a bad way, even though he did very bad things. Yeah. DM says, Gavin, the audacity. Is the defense trying to control the victim's impact statements? That's the way it seems to be. Garth Bnut says, Gavin, will the jury have to see the essay pictures videos? That would be horrible for me to see this filth if I was on a jury. Poor little Maddie. I have never been in a courtroom in a case like this where there was essay involved. I would guess, one, this is Florida, so there are open records, or there are open meetings laws and open records laws. But the judge has discretion for a lot of things. Sometimes, in some cases where I've been, they will publish things to the jury by handing them like closed folders that they can open and look at, and then they have to close them and give them back so that the gallery cannot see that thing. But that has been in cases where it didn't have anything to do with SA. So will the jury have to see it? I don't know. What's more likely, I think, is that the the jury will hear descriptions of it. That's my guess. That's my guess. And that's all it is. It's just a guess. Yeah, I would hate to be on a jury and have to do this. Jess Z says, Gavin, as for the title, I will never ever feel sorry for the monster that is Stephan Sterns. Yeah. Karen, Gavin, I don't know if Maddie's mother, Jen Soto, would say that she was affected by the death of her daughter. She'd probably apologize to him. She tried to cover for him at every opportunity. Such a tragedy. I was kind of thinking the same thing, Karen, but there are people that I think deeply, deeply loved Maddie. I think that her grandfather did. I think that her stepfather did. I think that her aunt did, and I think that her grandma did. I think that there would be plenty. I love this picture of Maddie with her grandfather. I think there would be plenty that would want to make statements to the court. Jennifer Soto, I don't know. Lori Ann McDonald, Gavin, all these motions trying to make him look less like a monster make it seem like he doesn't feel like he did anything wrong. That is one of the things that is irksome in cases like this, right? That they're fighting for their life. We want them to be able to have a competent defense, though. That's the thing, is that we want to protect the fidelity of the law, the fidelity of the process. We want Mr. Sterns to have a vigorous and competent defense. But you're right. It does feel like, they're like, hey, wait a minute. I didn't do anything wrong. I will say, though, Lorianne McDonald, in trials that I cover where there is just so much overwhelming evidence against the defendant that it's almost like there isn't even a question, the attorney typically, you can typically tell that the attorney knows they have nothing by the questions that they do or don't ask. Okay, a couple more real quick. Helen, is the trial for the SA to be this month? If so, do you think it will happen or be put to another date or month? Yeah, it is scheduled. Last time I looked, which was 3 or 4 days ago, it was still scheduled for February 22nd. There's no chance on this beautiful blue and green globe that we live on that will happen on February 22nd. Guys, it just doesn't happen. I was talking to a defense attorney today. The trial that I was covering today was from the time that the crime occurred to the trial beginning was less than 14 months. That never happens. It was crazy that it has happened that fast with this many motions. And I know that this is the murder side of things, but it's the same attorneys. No, they are going to, it is not going to be February 22nd. 11 days from now? No. No. Let's see. Demon Hugger's Friend, who I declare has the second greatest username on YouTube, says, Gavin, evidence, does that only mean physical evidence or also non-physical evidence? I'm not sure how to accurately ask this question. I think they're talking about like impact evidence. So yeah, I think that the physical evidence, I think there will be a lot of physical evidence in this case. I think there will be a lot of circumstantial evidence in this case as well. And I think they'll be able to present that to the jury. Okay, great comments, everybody. Let's head on back over to this document here. Okay. Let's see. I think we're in paragraph 8. Finally, sympathy evidence is clearly inadmissible under Florida law. We're talking about sympathy evidence, not physical evidence, right? A long line of Florida cases, as detailed in Jones above, prohibit such evidence in the guilt-innocence phase. The introduction of such evidence in the penalty phase or before the judge would violate the clear limits on aggravating circumstances imposed by the statute that they've mentioned a million times and the case Grossman above. The Florida Supreme Court has implicitly recognized that pain above has no impact on cases such as Jones and Grossman, as they are based on Florida law. In Taylor v. White, the Florida Supreme Court reversed for a new penalty phase due to a prosecutor making an argument designed to invoke sympathy for the deceased. Okay. So the court relied on its prior opinion in Hudson v. State, in which it held such argument to be improper because it urged consideration of factors outside the scope of the jury's deliberation. The opinion in Taylor was issued June 27, 1991, the same day as Payne. The Florida Supreme Court denied rehearing without modifying the opinion on August 20th, 91, well after Payne. This was an implicit recognition that Florida law continued to prohibit this kind of evidence at both phases and at sentencing. I honestly just feel like this is just there as a mechanism to get an appeal later. That's the way it feels to me. Let me just see if we'll come back. What page am I on? 5? Yeah. Okay. So the later edition of Florida statutes, blah, 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 does not allow the introduction of this type of evidence. This is true for 3 separate reasons. This evidence is still irrelevant to the statutory aggravated circumstances. I wonder what the aggravating circumstances are in this case. I mean, it would have to be the SA, right? Therefore, let's see there. I wonder what the aggravated circumstances are. That she was a minor is probably an aggravated circumstance. Maybe that he was trying to cover up other crimes. Curious what they are. Okay. 2, the statute is unconstitutional under the Florida and United States constitutions because the legislature had no authority to pass such a law as it violates the exclusive right of the Florida Supreme Court to regulate practice and procedure pursuant to Article 5, Section 2 of the Florida Constitution, and because it's violative of Article 1, Sections 2, 9, 17, and 21 of the Florida Constitution and the 5th, 6th, 8th, and 14th Amendments of the United States, both in effect and on its face, as it is vague and overbroad. And 3, the admission of this type of evidence would render Florida's capital felony statute unconstitutional under the Florida and United States constitutions, as it would leave the jury without any guidance as to how to evaluate this very emotional type of evidence. Moreover, Florida Statute Section 921-141-7 does not change the traditional rule that evidence must be relevant to the admissible. The statute states victim impact evidence. Once the prosecution has provided evidence of the existence of one or more aggravated circumstances as described in subsection 6, the prosecution may introduce and subsequently argue victim impact evidence. Such evidence shall be designed to demonstrate the victim's uniqueness as an individual human being and the resultant loss to the community's members by the victim's death. Characterizations and opinions about the crime, the defendant, and the appropriate sentence shall not be permitted as part of impact evidence. I want to look up which aggravating circumstances are in that. Let me see if I can. What was it? 141-7. Oh, there are a bunch of them. Let's see. 5, A, B, C, D, E, F, G, H, I, J, K, L, M, N. 7. Oh, wait a minute. They're saying Oh, I'm supposed to be looking at subsection 6. Aggravating factors. Okay, I was looking at mitigating factors. Let me bring you guys over here real quick. Let's see if I can figure out a way to make that easier. Okay. Aggravated factors shall be limited to the following. The capital felony was committed by a person previously convicted of a felony and under sentence of imprisonment or placed on community control or on felony probation. I wonder if that's why they are doing 2 separate trials, to convict him of a felony first. The defendant was previously convicted of another capital felony or a felony involving the use or threat of violence to a person. The defendant knowingly created a great risk of death to many persons. I don't think that one applies. The capital felony was committed while the defendant was engaged or was an accomplice in the commission or the attempt to commit, or flight after committing or attempting to commit any robbery, SB, there it is, aggravated child abuse, abuse of an elderly person, or disabled adult, blah, blah, blah. And I know, I'm yada yadaing. That's all important stuff. But okay, so that's an aggravating factor. Let's see if there are any other pecuniary gain, law for exercise. No, maybe that one. Maybe that one. Ooh, so close to that one. Oh my goodness. That one would have applied, what, like 4 days earlier? Or less. I can't remember exactly, but okay. All right. So that helped. That helped me anyway. I hope that helped you guys. Evidence must be relevant and admissible. Okay. This section must be read in conjunction with subsection 6 of the same statute, which states aggravated circumstances shall be limited to the following, and then lists the statutory aggravators. The Florida Supreme Court has consistently held that the prosecution is limited to statutory aggravating factors. I think there were statutory aggravating factors there. Okay. The United States, blah, blah, blah. Okay. I want to skip ahead a little bit because I think that let's see if this is a long freaking thing. No, I think we got the point. I honestly think that they're doing this just as a lever that they can pull when they lose and they want to appeal. That's what it feels like to me. Let's go over to your comments here. I'm going to go from the bottom up now. There we go. Okay. Gavin, the defense attorneys are trying to provide their client with what they think is a fair trial. It must be a tough job to do working for someone like Stephan Sterns when it's clear what he's done. I don't think it's all that difficult of a job for a defense attorney, and I'm glad that it's not. I once talked to a defense attorney, a competent defense attorney who had just lost a case where his client was obviously guilty. And I was like, man, sorry for the loss, buddy. And he goes, no, that person got their constitutional rights protected. And, we went through the process. They found him guilty. I don't mind the loss as long as the Constitution was followed. I think it probably is tough in that you're right. Actually, Becca, let me play devil's advocate to what I just said. I think it is probably tough for them with the evidence that they have to look at, stuff like that. I bet you're right. That is difficult. Autumn, thank you for gifting memberships. Very kind. Autumn is the best. Guys, hey, let's take a break for a moment. Real quick, head over to my website. So many of you are taking care of Autumn, my lead mod. If you ever want to do that, just go to my website. There's always a link below. Go to support me and scroll down to the bottom to the biggest thing. And I keep saying I need to move this to the top. you can buy Autumn a coffee. Just click on this button. So many of you are taking care of Autumn, and I love it. Thank you for doing that, and thank you, Autumn, and all the other mods for all your hard work here on the site. And Autumn, thanks for taking care of everybody else by gifting memberships. That was awesome. Let's see. Karen M. Gavin, there's over 1,700 photos, right? It's photos and videos. Do the attorneys really think they can do something to prevent the prosecution from showing those? No, I think that's direct evidence. I think that's direct evidence. It's not sympathy evidence. I don't think that those will be inadmissible at all. I'm getting the vibe, says Pink Vivi, that Jen got annoyed that Stephan killed her. I think she knew when it happened. Okay, yeah. Karen, our justice system is for all the criminal and slaps victims in the face. Terrible. You know, I don't share that sentiment at all. I don't share that sentiment at all. Now, I realize that there are protections for criminals. I realize there are, but those same protections apply to non-criminals as well. And that's the important part, is that, for example, let's take Miranda, right? It would be very easy for an innocent person to incriminate or to say something that would be taken as incriminating and then be charged for something that they didn't do. And I think it probably happens more often than we want to admit. So while criminals do take advantage of rules that were intended to protect the innocent, I think it's still important that we have those protections. In one of the videos we watched today in trial, the officer said multiple times, you've been Mirandized, you don't have to speak to us, that anything that you say can be used against you. You still want to talk to us, right? He did that 3 times after the Miranda warning, just kept saying, you realize you don't need to talk to us. We don't have to be here. Right. Which I thought was amazing. And of course, the criminal, because he's an idiot, kept talking. So anyway, I see where you're coming from, Karen. I don't share your sentiment. The chick Chanel, Gavin, are there any updates on Jen Soto? Do you think she'll be a witness? Do you think Stephan will plead out? I do think that Jen will be a witness. I don't know any updates on her, and I think the likelihood of Sterns pleading out is high because the likelihood of anyone pleading out is high. But if you guys will remember, Duty Ron was following along on one of the videos that I did. He was commenting in the live stream, and he said that he would bet his pension that this will go to trial. And so Ron knows way more than I do, has way more experience on that. He thinks that it would go to trial. I think it's unlikely. Jersey Red says, I believe both attorneys stipulate that there is SA, but don't actually show the pictures. I hope that is the case. I would imagine they would try to protect people from that. Mad Monkey 2, which implies that there is at least one other Mad Monkey. If the DP falls through with this trial, does that mean that they will try it again with the murder trial? Well, let's see. First off, you're right. There are 2 different cases going on here, but the one that we're talking about specifically today is the murder trial. In the SA trial, or the SB trial is really what it is, they're not seeking death. They could under Florida law, but they are not doing that. Let's see if there's... Okay, go back to the bottom. Just make sure. Shiny Star, thank you very much for the super chat. I appreciate that very much. Let's see if there's anything else here. I think we've got everybody. Thanks for that shiny star. Guys, I have to apologize, but I honestly have just had enough of the day. I love little Miss Maddie. I am grateful that the case is moving along. I just really, really need to decompress. So this one's a little shorter than normal, but boy, am I glad that you joined me tonight. You guys are awesome. Let me just bring up over here on ye old YouTube channel. If you go to my channel, you will see that tomorrow we're going to be listening to a couple of recordings, and we're going to be talking a little bit about what Jen may or may not have known. I honestly think that she had to know what was going on, but we're going to listen to some of the stuff that that has come out recently, some of those recordings. So please come back tomorrow night at 7:30 p.m. Eastern. I again will be coming off of covering a trial for my day job. I probably will be a little deflated. And I sure appreciate you guys for giving me the old attaboys and pats on the back and helping me out, because it is a long day these days where I'm covering a trial during the day and reporting on it, and then coming in and talking with you fine folks. But that's what we'll be doing tomorrow. On Thursday, Elizabeth Jones is coming back. We're going to be talking about the deposition that Sheriff Mickey Steins took on Monday, on the Monday before he then went and shot and killed Judge Kevin Mullins on Thursday. It's about a 200-page deposition, and when I got it, I immediately sent it to Elizabeth because I knew that she would just dive right in. So she and I are going to talk about that on Thursday. And then on Friday, looks like Donna Adelson. She has teeny tiny ear canals and also is being beat up. So she wants some protective custody. She has gotten it, and we're going to talk a little bit about that. Okay. Let's see. Remember that you can always join us over on the Fish Tank, which is where we hang out on Facebook. There are about 3,500 of us in there. This is actually the case right here, the murder of little Mr. Oh my goodness, this little boy, Keaton Morrison, was 2 years old. That is the case that I am covering this week. I've been covering for the last year. So we talk about all sorts of things, not just the cases that we're talking about here on YouTube. So join us over there on Facebook. Last thing I want to bring to your attention. Oh, second to last thing. Definitely go over to Crime Cod, sign up for the newsletter for my true crime website. And then lastly, remember that you can go to Madeline's case page on my website that has so much information, guys. So much information. Audio recordings, case documents, timelines, crime scene photos. So much. I mean, just so much. So definitely head over there. With that, thank you for joining me tonight. I will see you tomorrow night at 7:30, I hope. Until then, I bid you adieu. Take care of yourselves. Bye-bye. Thank you very much for watching this video. If you liked what you saw, please consider subscribing. And if you have any questions or comments, please leave them below.